My name is Rachel Bickler of the law firm CMS, and I have the privilege of welcoming you all to this morning's panel on behalf of the Brussels offices of the Law Society. Is that right? An association representing 180,000 lawyers from all UK jurisdictions, whether based in the UK or abroad. On behalf of its members, the Law Society has a role in advancing the debate on the quality of regulation and engaging with legislators in the formulation and implementation of regulation at both the EU and national levels. All of us who are here today recognise that big data and the regulatory issues that surround it focus on some of the key challenges which face the digital society as it moves to the next stages of development. And it's a keen issue of interest to the Law Society, touching, as it does, on key areas of law, business, and the rights of citizens. This morning's topic, big data, friend or foe. Let me set the scene for you a little bit before I introduce you to our eminent panel. Big data. When we're talking about it today, we've had mass information for a long time, but when we're talking about today is a relatively new phenomenon. The name, of course, focuses on the idea of size and volume, and there's no doubting the fact that our capacity to generate data has increased exponentially. In preparing for today, I've been hearing about all sorts of statistics which sort of helps one visualize. I was told of a recent report by IBM Marketing Cloud which estimates that 90% of all data has been generated in the last 2 years. I'm not quite sure what they've been measuring, but there you go. Somebody else said that even as far back as 2013, if you amassed all the data on CD-ROM, some of you will remember what those look like, and stack them up, they would make a tower, 5 towers reaching the moon. In any event, volume, of course, is only one element of this story. What we're also talking about is data assets which are characterized by velocity and variety. Velocity in the speed of generating, processing, and analyzing data, and variety in the sheer diversity of information gathered. But ultimately, that data only has value if it's held and analyzed, and that requires specific information architecture and infrastructure, new technology, and increasingly refined analytical tools. All these characteristics, concentration of data, speed of development, processing, and analysis, are themes which we'll come back to as part of the regulatory debate. The second part of our title is friend or foe, and what do we really mean by that? Friend is being used as a sort of short form to reference the transformational benefits that big data offers in society. And it is ubiquitous today, as we know. It impacts on everything we do, from goods and services, the news we read, the way we do business, how our public sector functions and how it predicts what the needs will be for the future, developments in medical care, our ability to predict natural disasters and weather patterns, even the way we financing things like crowdsourcing of new innovative products and the way we communicate. I was recently made aware of just how ubiquitous it is when I was talking to an archaeologist who was telling me about the specialist analytical tools that he was learning to develop for use in his work. The word friend also reminds us, when we're speaking about the essential task of regulating to protect citizens, consumers, and innovation, that we're also regulating to protect and advance the benefits of big data, as well as mitigating the risks that may be associated with collection and use. The word friend also is a reminder that in some instances, there is also obviously an incentive to self-regulate. It doesn't have to come from the top. The word foe is a strong word, but really what we're trying to evoke is the notion of risk. And for those of us who are lawyers, what we sometimes reference as theory of harm. As with all transformational stages in society, big data offers challenges for stakeholders, all of you. The concentration of data in hands of a few players and their increased capacity to obtain information regarding virtually all aspects of our life raises new challenges for regulators in fields such as competition, policy, consumer protection, protection of fundamental rights, and of course, cybersecurity. Transparency, often regarded as a regulatory virtue when we talk about access to information, can also raise a raft of issues over privacy of private data. It is a balancing act. From a regulatory perspective, one of the greatest challenges is the speed at which things are processed and analysed and the use of sophisticated algorithms in the marketplace. This is starting to raise questions about the adequacy of our current rules to manage issues such as collusion from a competition law perspective and liability issues from regulatory and contract law perspectives. Often when you hear big data being debated, it seems to generate sort of extremes of thought about utopia or dystopic futures. Of course, as ever, the truth lies between, and we're very fortunate today in having a panel of experts who are able to bring a wealth of understanding and experience to the table and to be able to debate all of these very complex underlying issues and reflect upon very different perspectives that we have to take into account. And with this in mind, I'd like to introduce our panel today. Cyril Ritter, who's sitting just here to my left, is an official from the European Commission's policy unit dealing with antitrust in a whole range of different areas, including technology. He will, of course, be speaking today in his own capacity, but he'll be able to talk to us about competition policy, some of the recent law issues around structures of market, mergers, and even how competition law and privacy interact. Professor Niko Van Wyk, immediately to his left, is a professor of information law at the University of Amsterdam and a director at the Institute for Information Law. He's able to speak to us today about unfair commercial practices and the use of EU enforcement laws from privacy. I know that he has also a lot of experience about with looking at what is happening on the international scene, liaising with issues and looking at how, for example, the Federal Trade Commission are dealing with some of these issues. Reagan McDonald, who is on his left, leads Mozilla's public policy work in the EU, dealing on issues related to the digital single market strategy. And she can provide some light on the role of industry on self-regulation, choosing pro-privacy solutions and the challenges that industry faces. Ralf Bendrath, who's on her left, is a political scientist and a policy advisor at the European Policy on Civil Liberties and Privacy, working with the MEP, Jan-Philippe Albrecht. He's also active in several NGO networks on European digital rights, and he brings to the table insights on the integration of fundamental rights in competition and consumer law. The way we're going to run this panel today, and I'm so pleased to see so many of you here, but we have some seats in the front if you want to make your way across before the panel starts to speak. So please come and join us if you'd like to. We will set the scene initially by allowing each panelist to present their own perspective on the topic and briefly outline the issues that they see in their own fields. Then we'll move into the second part, and the third part, which will be more of the debate. And that will be led out in two areas. And one will be to talk about whether the existing toolbox we have, both regulatory and industry responses, are sufficient to meet the challenges that we deal with today. And the third part, how we make sure that we apply the regulations in a joined-up manner. We would then like to have the time to have audience participation. By that time, I hope you'll have lots of stimulating ideas, thoughts, and questions for the panel. And then we hope to finish at 1:15 to free you all up for your lunch. I'm delighted to say that to moderate this debate, we are very lucky to have Jeremy Rollison, who is Director of EU Government Affairs for Microsoft's Corporate External Legal and Affairs Group, and of course is deeply engaged in issues and policies surrounding current debates in the digital place. So I will hand over to him for the panel debate.
Thank you, Rachel. And I do think that sets the scene nicely. I've had the privilege and pleasure of speaking at CPD before as a speaker, so I'm looking forward to asking questions today instead of answering any. So I'm going to leave the floor to the panelists. We're going to hear from Cyril first, and then I think we're going to move to Nico, followed by Raegan, and then Ralf. It's okay, we'll have you be in the luxurious position of being able to address everything everyone had said after that. But I would like to make sure we allow time for a back and forth on some of the points that I think will overlap here, as Rachel said, and we'd like to get questions from everyone in the audience. So with that, Cyril, why don't we let you continue to set the stage?
Thanks, Jeremy. Can you all hear me well, including at the back? Thanks. Looking at these digital and data issues from a competition perspective, I think it's clear that there are two claims or two issues, and I'm not taking sides here, one way or the other, but at least there are two claims out there. One is that the digital platforms or the digital giants don't provide enough privacy or enough data protection to their users or consumers, customers. And another claim, which is often made, is that there's an increasing risk of data accumulation in the hands of some of these digital giants. And so how do we tackle these two issues, using the whole range of policy responses that we could have, consumer protection, data protection, consumer competition policy. I think when we look at the way all these policies come together, my own personal perspective would be one perspective of humility and probably a quite modest perspective. I think it's necessary to acknowledge the links between all these different policies, and it's also necessary to acknowledge the complexity of all these issues. And so step one would probably be to not make any overly broad statements or not make any definitive statements one way or the other. And another probably another good recipe to get into this debate would be to try to separate the issues while at the same time acknowledging the links. So I realize that those are a little bit contrary messages, but it's important to separate out the issues so that we can have clear discussions of, on one side, AI regulation or personalized pricing or fake news, or platform regulation. These are all different issues. They're also interlinked, but so it's important to have, I think, that dual perspective on that. My next point is about telling you how we've been trying in DG Comp, in the European Commission's DG Comp, how we've been trying to conceptualize these data issues. And I think it's useful to go back to the way we see assets or activities in competition cases. You can see data as an output. Of course, if you're a trader and you're looking at your Bloomberg terminal, you're in your bank, or you're looking at your Thomson Reuters terminal, you see a constant flow or stream of financial data, and that data is being bought, so that is data as an output. That's a stream of data. If you're a supermarket, you can go to AC Nielsen and you can get the supermarket scanner data, and you can buy that from AC Nielsen, and that is again an example of data as an output. And from that point of view, you could say it's not really different from any other output, any other product or service which is being sold, like cars or services or beans or anything. Subject to the fact that some of those data include personal data, so of course there's a personal data angle, there's a human dignity and fundamental rights angle, but basically it's data as an output. You could turn things around and say, okay, those data are also an input. So maybe I buy data and I use that as an input. Or maybe I buy a company that has a lot of data. So maybe I'm a bigger digital firm and I go out and buy WhatsApp or another smaller firm that has a lot of data, and I acquire data that way. Or maybe I acquire data because I have a product that generates data, or my users' interaction with my product allows me to collect data from users. So if I have a search engine, if I have a social network, I of course collect data from consumers, not only from the moment they sign up, but also from their daily interaction with my product. So I could also collect data that way, and that volume of data is an input that I use. And what do you do from a competition perspective? What do you do with inputs? What do you do with assets or inputs that firms typically hold? Typically, you leave them alone. I mean, typically, you let them do whatever they want with their assets that they have bought or that they have generated themselves. except in a few cases where you believe that there's a competition issue, because, for example, the merger is allowing the merged, or would allow the merged entity to gain such an insurmountable advantage, from having accumulated such a large share of the input, that insurmountable advantage could not be matched by other companies in the market. So perhaps you could have an input accumulation merger theory of harm there, or in this case a data accumulation theory of harm. Perhaps you could do the same with Article 102. You could say, well, this dominant firm, has really collected too much data and should really share it. Again, I'm not trying to suggest that we will go out and expropriate people's data, left and right. But I think there's a reasonable argument that in the same way that competition authorities have been using this duty to provide, quite rarely, to be honest, competition authorities use that very rarely, but the same framework could conceivably apply to data. And finally, there's a third perspective, which is neither data as an output nor data as an input. It's data as a currency. It's what my Commissioner Vestager, often says. All these free products on the internet are of course provided for free, but there's no explicit price. There's no monetary price, but there's a price in the sense of you pay with your own data. And I think that's an accurate image, but it a little bit puts too much emphasis on the way that we hand over our data as if it was euros, as if it was a currency, and perhaps it doesn't put enough emphasis, or it doesn't illustrate enough the angle that it's not only about how much data I hand over, it's also how protectively my data are being treated by whatever online service provider I'm dealing with. So it's not only about how much data I give, but it's also about how protectively those data are treated. How long the firm keeps my data, with whom do they share it, do they inform me correctly of the purposes of data collection. And if some people are privacy conscious, and not many people are privacy conscious. Of course, this is a bit of a biased audience, because I think we're all privacy conscious in this audience. But I think in the general public, not many people are privacy conscious. And so, if in the future, as data protection gains a higher and higher profile in society, if people become more and more privacy conscious, you could imagine some competition on this aspect. So firms competing with each other on providing good data protection to users who are conscious of it. And so you could say this data as a currency angle is actually the same as data protection as an element of quality. So could firms compete on this element of quality? Firms do already compete on this aspect. I know about all the search engines and social networks that market themselves as providing good data protection. It tends to be a little bit, for the moment, fringe services, but they are certainly growing, and I would expect that in the future, that kind of competition on data protection, providing good quality to users on this dimension, I would expect that would grow, and with that kind of competition growing, then we would need to look at potential restrictions on that kind of competition. And could you restrict competition on this data protection as quality angle? You could restrict that through a cartel, of course. You could restrict that through a merger. If you take out a smaller competitor who was previously competing with you on this angle. You could also restrict competition on quality in this respect if you're a dominant firm, and if you degrade the privacy policy that you give to your users. This is something that we may see something coming out of that from the theory that the German Competition Authority is using in the Facebook case at the moment. And so these are just roughly speaking the pointers that I would use to set the scene for this discussion. Jeremy.
No, thank you, Cyril. And I think that's absolutely appropriate. And I think it's the best way to start. I think we often think of, in the title of the panel and the description, I think we're looking at competition rules here, and I think you've set the stage well. Some of the questions we'll get to later will be, are these toolboxes that are available to competition authorities sufficient to address some of the challenges? But before we get into that later, I wanted to hand over to Nico, who can also talk about some of the additional ways that challenges, let's use that word for now, in big data. What are some of the other regulatory toolboxes that are applicable and could be used to address those, perhaps more efficiently or perhaps in conjunction with others?
Thank you, Jeremy. I couldn't attend Cpdp yesterday because I had to speak at an event of the European media regulators. And the entire morning I've been trying to find out whether anyone who was in that room was also attending this conference. And I found one, Mark Cole, who was the other invited guest to speak at this event. What were these media regulators talking about? All the new changes, in particular the importance of new audiovisual media service providers, and for them that was like Netflix, Facebook, Google, and privacy and data were words that were not used in the room. It was all about traditional approaches to media. And that's where I once again saw that in regulation, in enforcement, we have still a very, very silo-oriented approach. Well, I think we all recognize that these problems are not just privacy issues, they are not just media issues, they are not just competition issues, they are not just consumer issues. And this requires a kind of 360-degree approach. Jeremy already mentioned the word toolbox, and for me a toolbox is something that is filled with creativity and filled with opportunities to deal with issues that we want to solve. If a plumber comes to you to solve a leak and he has not the right wrench with him, he should not go home and say, I don't have the right wrench. He should look in his toolbox and he should find something that can help you. I think that's very, very important, and we are too often ignoring that by having a silo approach, that other remedies might be available to solve the issues. Other remedies that might even be more appropriate than the most silo-oriented approach. This is where we have to be very careful about the famous hammer-nail issue. If your hammer is media, you tend to see everything as a media problem. If your hammer is privacy, you tend to see everything as a privacy problem. I don't think that is the right approach. A lot of the issues that we, for example, call privacy issues are about competition. It was just mentioned already. A lot of these issues are about consumers who feel that they are being deceived, that they are being misled. And yes, there is a privacy element to it also. But when on Saturday morning I don't receive my newspaper, I have a digital subscription with the exception of Saturday. On Saturday I get the paper version of the newspaper. And I don't find it in my letterbox. What do? I call the newspaper. But I don't start by saying, you have infringed my freedom of expression. I say, where is my goddamned paper? It's a consumer issue. It has nothing to do with freedom of expression as such. So when I was part of a project called Privacy Bridges, where we tried to look into the differences and the commonalities between Europe and the US, I was amazed by the fact that European DPAs see the Federal Trade Commission as their counterpartner in matters that are about privacy. And yes, the FTC has dealt with a lot of issues that were about data and that were about privacy, but they do that from a totally different perspective than the European perspective. There is this famous Article 5, Section 5 in the Federal Trade Act about misleading and deceptive practices, and that's the tool that they apply. Interestingly, in Europe we have a similar tool. We have a regulation on unfair business practices that largely equals and actually is even more powerful than this famous Section 5 in the US, in the Federal Trade Act. For example, a big difference is that in unfair business practices in Europe we have a so-called blacklist. It doesn't matter whether there is actual harm, because that's what often needs to be proven in a US context. If you are engaging in an activity that's on this blacklist, you're infringing the rules, and it doesn't matter whether there is damage or not. So we basically have the same tool available, and that puts on the table why are we not using, in a kind of complementary way, in particular when it is about unfair business practices, when it is about deceiving customers, why are we not also looking at these tools that we have available? And I think the main reason why that is again because we have this silo thinking, and we have to go beyond these silos, and we have to understand that we need a kind of more horizontal approach So it's not the pillar, it's like, how can we solve the problems that we are facing? And what are the most effective tools? What might be the most efficient tools? And then there's one thing I'd like to add. It's also not about the regulation as such. Again, for every problem that you would explain to me, I can guarantee you that I have at least 3 regulatory instruments that could be used, or with a little bit of tweaking could be used. The problem, I think, in Europe, and that's also what was very interesting in looking at the American model, is we need enforcement. And enforcement in Europe is very young, has very little practice. The Federal Trade Commission is more than 100 years old. Most of the regulators we have in Europe, particularly when it comes to privacy, are relatively young, are still at the beginning of a learning curve. And that's a lengthy process and a complicated process. When 25 years ago we were asked by the OECD to look into new telco regulation in former communist states, we saw a tremendous problem that had nothing to do with regulation. So what happened was these countries got huge amounts of money from the European Union and from European funds, and they could only spend that money by hiring Western consultants that would then draft a new law for Romania, for Hungary, for the Ukraine, and they all came up with actually wishful thinking that they were not able to sell in Western Europe. So these newer countries got regulation that they could not familiarize with that. So we talked to people from these countries, and they just didn't understand what we were talking about. Let me give you an example. We had people from the Ukraine, and we asked them, how much do you bill for a call per minute? And there was a problem with the translation, and there was again a problem with the translation, and then it turned out that in the Ukraine they didn't bill per minute, because the telephone system was run by the government and by the military, and there was no reason to bill. So, and then regulatory concepts like enforcement were totally out of the scope, because everything was government, so there was no need to enforce because you could only comply. And so the outcome of it was nice that they had new regulations. Regulation didn't work because it was based on Western concepts. And second, it doesn't matter what kind of regulation that you have. It's because the people were not equipped, were not trained to deal with this. And this is where, and maybe I'm a little bit over-exaggerating, there is a big difference between serving tea and enforcing. And enforcing is a skill that you have to learn, that you have to be trained in. And therefore, for me, enforcement is something that should be part of the equation. So if we have other regulatory remedies, which might also be applicable in the case, like unfair business practices, and the regulators in the context of unfair business practices have a much more stronger background in enforcement, then maybe we should consider to use those tools instead of the tools that might, because we are a hammer-nail person, might be the most obvious ones, being privacy ones. So I would very much say these problems are very serious problems. They require a 360-degree approach, and it's not just about privacy. It's about much more. Thank you.
Thank you, Nico. And Raegan, I know that you've had some exposure to these from a variety, all these different issues from a variety of angles. Let's, I think Nico set the scene well, and anxious to hear what you have to say about it.
Thanks, Jeremy. Good morning, everyone. I will share some thoughts today about how Mozilla approaches the issues of competition, particularly in the context of privacy and data protection. As a mission-driven tech company that builds open source software, we are very much of the general mindset that competition, choice, and decentralization are really key tenets for any type of healthy internet ecosystem. So the openness and opportunity on the internet, basically its disruptive nature, is exactly what has enabled this sort of fantastic economic and social success of the internet. But today, I think that disruptive nature is very much in question. Is the internet actually disruptive? I think the answer could be no in a lot of ways. Silos and devices, platforms, content, services have all come to dominate the technology ecosystem. And these silos, or walled gardens, are basically popular because they provide a really clean user interface and give access to the most popular tech offerings. But these silos are becoming more and more closed. and disruptive upstarts are finding it harder and harder to compete on a level playing field, which then results in fewer and fewer choices for users. So I think this is also the case for big data. As the space continues to converge, access to these gigantic data sets, which is required for innovation and to compete and to be relevant, is increasingly restricted into the hands of a few, which essentially restricts access to innovation. And I think this is a challenge where policies around openness, like portability and interoperability, and other innovation solutions and innovative solutions need to be forged. So from our point of view, competition, especially today, is an increasingly important field that we want to unpack. I think both on the big C competition in terms of antitrust law, thinking about whether or not competition law is suited to address the challenges of today, or whether it would require some tweaks, but also thinking about competition generally in the small c sense, because it's also not just about remedies and enforcement, but about creating building blocks and creating in the field of internet policy to have all sorts of overlapping policies where competition elements can be found in other public policy issues. So, for instance, there's currently a copyright law is being negotiated here in Brussels. There is a proposal to expand copyright to cover snippets, and this has been driven by press publishers in order to have these large aggregators pay their fair share. The unfortunate issue is that in our view, this approach would actually further entrench a dominant market player and would be very harmful for competition. Likewise, if you look at other examples like net neutrality, the principle that traffic must be treated equally, this is a policy that promotes competition because it locks the networks open and preserves the low barrier to entry for new and smaller players. And it also keeps the incumbents in check. So when we look at data protection, privacy, and competition, I think there are a lot of helpful overlaps here too. And in short, I think privacy can be good for competition and competition can be good for privacy. So first off, if you look at data protection, there are some competition elements in there. The right to data portability, for instance, is very good to really give the individual control over their personal data, but it also really empowers them to truly vote with their feet because they can more easily choose and go to another service. But you also need meaningful choice because no matter how well or how easy the user can take their data, they need to actually have another option to move their data to. So you also need to have meaningful choice in the market if you're thinking about social networks or something, for instance, in order for the user to exercise their right to data protection. So to us, those are very overlapping and interdependent issues, both for data protection and for competition. And competition can be good for privacy. This is because essentially the less companies that you have in the market, it becomes more and more impossible to hold companies accountable for policies or for practices. And this absolutely relates to data protection practices, as Cyril mentioned, the German case that's being brought towards Facebook. So unless there is an actual threat or a choice that the user can leave a platform or has any kind of option, then there's very little incentive, I think, for the company to actually change their practices in a meaningful way that benefits the individual and suits the needs that they're looking for. And so one final thought on something else that we're seeing around privacy and competition that we would like to see more of is seeing privacy being used as a competitive advantage. So we're seeing more and more companies using privacy as a differentiator in the market and hoping to drive consumers and customers to their product because it is more privacy preserving. We don't know yet if that's enough to get customers away from those silos, to move them away from the big tech companies, but we do see this as a positive trend, and we hope to see more of it in the future. So I'll leave it there, and I look forward to the discussion.
Perfect.
Thanks.
Thank you, Rick. Ralf, I know you've been close to a lot of this. Continue to set the scene before we get to some questions. Anxious to hear what you have to say.
Yeah. Just a disclaimer. Contrary to my introduction, I'm not an expert in competition or consumer issues. I'm a data protection expert. The main reason is that I cover the Civil Liberties, Justice and Home Affairs Committee for Jan Albrecht, and my other colleague here covers the Internal Market and Consumer Protection Committee. Of course, we talk to each other, but yeah. So I will try to discuss a bit the position of the Parliament and what happened in the last years on data protection, how it relates to big data, but then also try to go beyond the personal data aspects at the end. So, of course, everybody here knows the GDPR. It was basically written on my laptop. So blame it on us. I think there's some elements, and probably most of you know this already, some elements in the GDPR are of course very relevant for the issue of big data. And one or two already are in Article 5. 5.1, data processing has to be fair and transparent. So that relates already to the fair business practices and so on. Transparent also is later then elaborated in the famous right to explanation, the right to be informed about the logic underlying the processing in Article 12. And then, of course, you have the article on automated individual decision making, including profiling, Article 22, which says that data subjects shouldn't be made subject to automated decisions based solely on automated processing, including profiling, which produce legal effects concerning him or her, or similarly significantly affect him or her. So basically, a machine, an algorithm, whatever you want to call it, a system shouldn't make decisions, maybe based on big data analysis, statistical probabilities, what have you, that directly affect a person. In a way, at least, that is comparable to a legal effect. That would be such as you don't get a credit, or things like that. There always should be a right to human intervention. And then again, the right to explanation, how this decision was actually made. There's certain academic literature around this now. Some people have challenged the existence of a right to explanation with reference to business secrecy and stuff like that. Others have counter-argued again, but there's also some interesting proposals now in the academic literature on how this can actually be implemented, because explaining an algorithm or the underlying training data or what have you to a normal person on the street, normal consumer, just won't work, you know? But it could make sense, for example, to just say, you have been offered this price for your flight booking or whatever because you have visited our website from an Apple Macintosh computer. That happens in the real world. Or you didn't get this credit offer because you already had two insolvency cases in your life, and we know that. Just to, you know, that would be a kind of meaningful information or explanation. But there's certainly a lot of work to do to really elaborate that more. Then what we also have in the GDPR is the privileged data processing provisions for further processing for statistical and research and historical archiving purposes. And of course, you could say big data is basically just statistics, you know, applied statistics. So there the GDPR already in a way addresses this. If you already have large amounts of data from other data operations, collections and so on, you can further process them and even keep them longer maybe if this helps you for statistical analysis. But then we also put the very important clarification in one of the recitals. It's always important to read the fine print, you know, that if you do this statistical processing, it shall only lead to aggregate results and not to individual profiles again. So you can use statistics to generate general insights, but not for individual profiling. And of course, we have the safeguards in Article 89 that you have to see if you cannot do your analysis with pseudonymized or even anonymized data. So you can only keep the personal, really individual personal data if you can't do it in any other way. And even then we have, of course, all the provisions on security and breach notifications and what have you, and then, of course, the big fines, up to 4% of annual worldwide turnover. So in a sense, I'm also telling data controllers since then, since 2 years ago, under the GDPR, data is not necessarily an asset. It is also a liability. Keep that in mind. Okay, so much for the GDPR. Then another thing, a bit more recent, is a report that was adopted by the European Parliament in March last year on fundamental rights implications of big data. That was started also in the Civil Liberties Committee. And we had to be very careful to say this is only about the fundamental rights implications and, you know, non-discrimination and so on. What about big data in the law enforcement context, predictive policing and so on. Because if we would have just spoken about big data in general, including with relation to competition and consumer aspects, then the other competent committees would have challenged our competence. Then you have the lengthy discussions in the conference of committee chairs and so on. So this focused more on our area of competence, on fundamental rights, basically. And in certain way, it goes beyond the GDPR already. It, for example, refers to something which we didn't manage to get to negotiate into the GDPR already, although we had it on our radar already, that I think Joe McNamee once called it pregnant data. So it means that if you have large amounts of data, you can infer more data from that. And in this big data report from March last year, the Parliament actually states that it's possible to infer, like taking an educated guess based on probabilities, from normal, non-sensitive data, you can infer sexual orientations or health information or what have you. So infer sensitive data, which has stricter limitations on how it can and when it can be processed. And this is referred to in the Parliament's report here. Something to keep in mind. Then, of course, a big discussion here is about discrimination, that we have to be very careful that statistical analysis based on big data doesn't lead to discrimination of certain groups by race, gender, whatever preferences. Because, and then the Parliament also here points to the fact that this is not mainly about the algorithms, it's more about the training data, at least for machine learning. If you take data from a society that is still to a certain extent male-dominated, you know, we don't have full gender equality yet in practice, in real life, and you take that, for example, if you look at wages and stuff like that, salaries. If we take the data we have in this, in a way, still biased, discriminating society, and put it into the big machine learning systems, and then they generate some kind of insights from that and use them, apply them again for further decisions and predictions and what have you. This would perpetuate the current gender-based biased situation, the inequality, so to speak. And that also is true for other aspects, of course. In the policing field, it's well known that there's a certain bias against people of color and so on. This really needs to be taken into account, and we make some propositions here on how in a business environment this could be translated into business processes, so to speak. For example, that you regularly, I don't know, once a year or so, have to do an assessment of the training data you have, of the results, and see if there's any kind of discriminatory effects in there. Yeah, one aspect the Parliament also points at is, but this is more about predictive policing, for example, which is not really relevant here for our competition and consumer discussion, but just so you know, there's several different ways how you can do predictive policing. You can, of course, do it in the very intrusive, data protection unfriendly way by making predictions about people, individuals. And this is really quite nasty, I would say, because it's only a statistical probability. Even if 1 million people who share 99.9% of the characteristics that I have. Even if 99.9% of those people have done something bad in the past, and you can infer a very high probability that I will also do the same thing at some point in the future, this very nasty thing. This is just a probability. It's an educated guess. It doesn't mean that I, as a person, as an individual, will really do this. You know? So that's really tricky to do this individual predictive policing. But of course, there's other ways. For example, you can use big data for predicting burglaries. If you have the experience that in the summer break, for example, in Brussels, people from Brussels will know that when everybody's on holiday in the south of France or so, there's a lot of burglaries here. And in certain neighborhoods, there's more than in others. If you know that, you can have more police patrolling those neighborhoods at night. It doesn't mean that you say this person will be a burglar. It just means we are aware of the fact that in this area or around these places there's a certain higher probability, so we have a closer look. And this is actually very privacy friendly and might be useful. Yeah, maybe a last point from this big data report, because that really relates to our panel here. The parliament here already points to the fact that we need closer collaboration among the different regulatory or supervisory authorities, namely data protection, consumer protection, and competition. And the Parliament explicitly here in this report welcomes the setting up of this digital clearinghouse that was established, I think, around a year ago, or kicked off at a conference the EDPS and the consumer groups were organizing together, where also the Competition Commissioner was speaking. Yeah, so that's where we are basically on the big data debate in the Parliament. Maybe one small element that's also going on with a link to the contract law discussion. You may know that for more than 2 years now, I think, there's been negotiations on a new directive for consumer contracts if you buy digital content online, the so-called Digital Content Directive. And there's now discussions right now going on that maybe it makes sense that if a company where you buy an online digital service, let's say Netflix or what have you, they process more data than is necessary for providing you with a service, which would be in breach of the prohibition of tying in the GDPR, then this breach of data protection law would automatically mean that your rights as a consumer have been infringed upon. And then consumer protection law kicks in or would kick in, so you would automatically have the right to terminate your contract and get your money back, so to speak. I find that a very helpful approach to combine best of both worlds, to consumer and data protection law. Okay, so much for personal data. If I have some time left.
If it's short, we're running out. Yeah.
Okay, just a few words on non-personal data, machine data, sensor data, which is really completely not related to any persons and in a way out of scope of this conference, but still in that area, Reagan already touched on that, we need to think more about the concept of open data, giving also smaller competitors or companies who enter the market later access to data and avoid big monopolies. But also if you think about we've had a discussion about the trade agreements in the last 2-3 years, starting with TTIP, but now also about the EU-Japan trade agreement and so on. And Politico just reported last week that there's now an agreed text on the Commission on the big question on how to deal with data flows and data transfers. If we keep personal data out of the trade agreements, like we have always asked for as a parliament, and regulate that in the data protection context, but what happens with non-personal data, sensor data? Let's imagine the European Union enters into a free trade agreement with an African country, Senegal, whoever. and puts a provision on the free flow of data in there. Wouldn't that lead, or couldn't that lead to a situation that the sensor data and machine data and everything from Senegal, let's say, is extracted there, generated there, but then in a way shipped to Europe, and the real creation of value and the profits and so on are generated here? Doesn't that a bit sound like in the old colonial days when minerals and ivory and whatever, caoutchouc, what have you, was extracted in Africa, but the real value and the money was made in Europe? So in a way, a new kind of digital colonialism. I think that's also something to maybe keep in mind, but that's already, of course, beyond competition and consumer law. It's just this digital fair trade idea has been going on in my mind for the last months.
Thank you, Ralf. I actually think that was a rather comprehensive way of looking at all of the different challenges here. I think you did make two important points, though, that I want to come back to and ask Cyril and Nico specifically. Ralf mentioned a lot of aspects of GDPR that I do think address some of the questions that come up in a big data context. And Nico, you had mentioned earlier some of the analogies to a toolbox. I think one of the questions we often have in big data, and what this panel maybe can help address, is, do we have the tools in place that would address some of these harms? Do we have the tools in place that would address some of the challenges and the opportunities at the same time? You mentioned the digital content directive earlier this year. I find that fascinating. That was addressing a very similar harm, let's call it, or challenge, that I thought at the time GDPR actually was addressing very adequately. Do we look at that as a gap that still needs to be filled, or does that create confusion? Nico, you're closer to some of the consumer policy. I want to give you and Cyril a chance. Cyril, from your perspective, you talked about the assumptions and acknowledgements that we have to have in a competition space. But getting back to that toolbox question, do you feel the competition authorities in Europe have the tools, at least, they need to do this? And Nico, do you feel like consumer protection policy there in conjunction with competition is at a place where it's adequately sufficient for that? And then we'll get a chance to hear from the audience as well.
Thanks. I'll take your question as really sort of divided in 2 points. Do we have the tools in place now that are completely satisfactory? Of course not. I think that's the common sense answer, is that the state of the world is not perfect, and so we should always strive for improvements. It's not meant as a criticism of any area of law, or certainly my employer, or certainly what I do or my colleagues do, but by definition, business moves so fast. You have new ideas, new business practices that are constantly popping up, and so of course regulation and enforcement are a little bit, trying to catch up. A little bit one step behind. It doesn't mean that they are late to fix things. I mean, enforcement can be effective, and certainly competition law is one of the most effective areas of enforcement in Europe today. But generally speaking, are we where we are? Are we where we want to be today? No, of course not, because we constantly have to look at how we can fix things in a better way. That's, I think, the common sense answer. And then I take your question as meaning something else, which is, do we really need new rules or new instruments? Not so much on the level of enforcement or keeping up with business practices, but do we really need new rules? And there, I think we get back to the classic topic of can competition law adapt to new phenomena? And on this point, I think competition law is actually quite unique in the sense that it's very concise. You only have basically Article 101, Article 102, which prohibit anti-competitive agreements and anti-competitive abuses of dominance, and you have another short regulation about mergers, but it's actually so concise that it's really multi-purpose. It can really be adapted to a wide variety of environments, of questions and issues, and because it is so adaptable, actually it's good to keep it that way and try to adapt it to new business practices rather than start thinking of new rules. If you go to the other side of the coin, which is regulation, I mean, typically you contrast regulation on one side and competition enforcement on the other side. Regulation is quite a different animal. Regulation is more sort of heavy-handed intervention. It's also a little bit slower in general because you need a few years, to think about new regulations, and there's a bit of a cost, thinking about new regulations. There's an enforcement cost, there's an implementation cost. It doesn't move as fast, I think, as competition law, but regulation can also be very useful. And I'll give you a quick example of a situation where regulation can be useful. If you have a recurring issue, which happens really across the market, instead of doing 100 competition cases, it's probably better to have regulation. So if you have a recurring issue, if you have a definable issue, if you have an issue which is bad or always bad or almost always bad, so that you don't need this case-by-case assessment that you do with competition law. If you have an issue which is recurring and always bad, then again, it's better to have regulation. So we constantly need to think of this equilibrium between competition law on one side, which is more sort of case-specific, case-by-case, more fast-moving, and regulation, which moves a bit more slowly, but it's actually more effective to tackle recurring issues which are always bad.
Thank you. I think you got to the nature of the question I was trying to ask, whether we need new proposals in that space. Nico.
Similar as to competition, I'm very much convinced that we have very strong consumer protection instruments. Again, the biggest issue is, are we using them or are we just ignoring them because we think that we have to solve privacy issues with privacy solutions? In the study we did on unfair business practices, we also touch upon the phenomenon of binding commitments, which is that's, let's say, the European word for what the FTC calls consent agreements. That's where you have a very, very powerful tool to negotiate a solution with a particular company. And some of these agreements, well, actually these agreements now cover almost all the larger internet companies, have far more stricter rules in them than we can even imagine from a European context. I just give the simple example. Google, Facebook are under a 20-year obligation of independent auditing of their privacy practices. That's something we have never heard of as a remedy in Europe. I think you can have such a remedy already based on existing rules or just by a little bit tweaking existing rules. But we have to dive into that, and we have to be willing to have a more guts and glory mentality with the existing regulations and rules that we have than to have this kind of escapism of saying we need new rules. Because with fast-moving targets, first of all, you need more generic rules, so competition rules, consumer rules, in order to cover quick changes. Secondly, new rules take 4-6 years to be put in place. So the most stupid argument that you can ever have if you say we have an important problem that we need to solve now is by following that by a statement of saying we need new rules. Because new rules means that everybody stops doing anything, because new rules means the old rules don't work, so why should we still enforce the old rules? Because we need new rules. And then new rules, first we need to have the new rules. And that takes another 4 to 6 years. And this is where really be more creative. Challenging creativity is far more important than be politically correct and say we need another rule, we need more details, we need more guidance, we need more this. Do. Act. And that's where I really think that we should. Again, you'll have these wrenches, you can have a multi-size wrench, so you normally don't apply that, because if you have a particular wrench you prefer the particular wrench, but in many cases it's far more practical to dive in your toolkit and to find a multi-purpose tool instead of having your toolkit filled with hundreds and hundreds of specified tools, because it has a weight you can't carry anymore. We need to be more proactive. Sorry.
No, I think that's, I do like the analogy. Raegan, I wanted to ask you, you said in one part, and I like the way, sometimes we're talking about competition with capital C or lowercase c, but you touched upon it from both sides. There's a space for business to compete to address some of these problems too. Some of these problems emerge and we see consumer demand react accordingly, and we see some problems, sometimes, not always here, but get addressed through some of that competition between businesses. How do you see this space with that capital C that Cyril had talked about in competition, and a lowercase c with competition amongst companies to provide, in this context, perhaps more privacy-friendly solutions?
It's still, I think, a nascent concept. privacy as a competitive advantage. I think from the consumer point of view, we've seen a change in user understanding and want for privacy. They care a lot more about privacy, especially after 2013, the Snowden disclosures. People have become very aware, or relatively aware, of the fact that, of what are the consequences of all of these, products and services that they use every day, of what their governments are up to, how much data is actually being generated all of the time. We're essentially hemorrhaging data. And I think people are just starting to understand that this can have a really significant impact on aspects of your life. Either you're being followed with ads across every device that you use, or worse things like being denied insurance, or not getting that job, or being fired because of a post on Facebook. So I think people are becoming more aware of this, and therefore seeking out products and services that can give them what they want, which is security and privacy. Generally, people want to make sure that their data will be kept safe, but then I think it comes down to that choice element. There's the option between a nice and very convenient service that may take a lot more data than they're comfortable with, as to another service that's kind of shoddy, or it's small and it's not integrated with vertically integrated with many other services. So I think for the consumer, for the user point of view, it's hard for them first to find those products, to know how to use them, and then to wean off of, I think, what are very easy services to use. But I actually want to come back to
It's okay, we're gonna let you finish and then we're gonna take some questions from the audience.
Okay, I just wanted to respond actually to what Nico's saying. I think that we agree in some ways on the fact that we should be holistic in our approach and thinking about all of the different tools that can be used. But I actually wouldn't go so favorably towards the US model of the FTC, because their model is very much premised on sanctioning harm when they have the resources and it's high profile enough to sanction that harm. What I think is good about the EU approach, particularly with the regulatory approach, it can be clunky, and we'll see what happens when the GDPR comes into force. But what it does is actually, like I said in the beginning, it creates those building blocks and changes behavior in order to avoid having to do enforcement, which is costly, which requires resources, and at the speed that tech goes, you can't be waiting for a long antitrust case, which can take up to a decade, and the damage can be done within a year. So I think it's actually helpful to think about how you can have this combination of like baseline rules and regulations and effective enforcement. And yes, enforcement will have to be something that EU DPAs think about how to do efficiently, but that can be, I think, a better situation than what you have on the other side of the Atlantic.
Okay, Nico, I do want to give you a chance to respond very quickly, and then I want to have time to collect questions from the audience, so we can still.
I'm fully aware of the downsides of the US system, so that's also why I made this remark that one of the advantages in unfair business practices when you compare the US with Europe is that you don't have to prove harm in the European context, so your biggest concern is addressed. And when I talk about enforcement for me is not 4% of global turnover as a sanction. That's also where these binding agreements, for example, the consent agreements in the US could be a much better option. Enforcement is not fines. Enforcement is far much more than fines. And that's where we can learn some things from the US practice. And yes, the US has another idea about privacy, but how they sometimes deal with enforcement, that's something where I think we can still learn a lot from, because they have a far more larger history there.
Okay. Thank you, Nico. Questions from the audience? I want to give you a chance. I see a hand there, and there. I saw your hand first. We'll come to you. We can collect them all at once, perhaps, or let's do them one at a time for now. We still have 15 minutes. So, yes.
Nicholas Harris from Disco. I've got a question which is mostly a Ralf, given that it seems that you've been following closely the implementation of GDPR since it was adopted, and Cyril may be able to chip in. It's just that when you look at competition cases where fines are sometimes as high as 4% of GDP of the turnover. The EU courts require DG Com to hold sort of internal devil's advocate panels, to all sorts of due process rights, to take notice of meetings. There's all sorts of due process rules that kick in once you start levying fines of that size. And so I'd be interested in, from what I see of data protection authorities, they don't seem equipped to undertake that sort of extensive investigation and offer those sorts of rights. Is this something that you've been looking at or that you're concerned at? And maybe Cyril, I don't know if there's something that DG Comp has been advising data protection authorities on how to enforce, how to conduct investigation.
Yeah, you're pointing at a difficult spot here, that's right. The thing is that under EU primary law, under the treaty, the data protection is kind of a unique field because it's the only field, policy field, where the supervisory authorities have to be independent, fully independent. So to a certain extent, they can do what they want in a way, within the scope, in the framework of the GDPR, of course. So of course, if they after 25th of May this year issue these very high fines, up to 4%, they of course will be challenged in court. That's clear. I really expect that, because companies don't want to pay 4%. So of course the data protection authorities that do this have to be on the safe side. They have to invest a lot of time and work and legal analysis and what have you, facts gathering, due process, to really make sure this would survive a court case. And for that, maybe not all of the DPAs are equipped yet, which is mainly the lack of resources. A lot of them are very small, have only a few staff. You might remember the story of the DPA in Ireland, which was sitting above the supermarket at Port Arlington and only had, I think, 6 people, and none of them was a lawyer. It's getting better now. So in that direction, we as legislator say in the GDPR something to the effect that the national data protection authorities have to be equipped so they can actually do their job. There were even proposals when we negotiated this to spell out more specifically how much money they would need, or to say that the size and the budget or whatever of a data protection authority should be proportionate to the size of the population or the amount of data processing that's taking place in that member state, which is already hard to measure. But then we would get into the problem that this would touch upon the budget autonomy of national parliaments, so that's the way it is.
Okay, thank you. I think that was more addressed to Nicholas's question. I wanted to give you a chance. You had raised your hand. Another question?
I have a question around the data for innovation that Reagan and Ralf touched upon. We do need it. A lot of people don't have it. Some few companies haven't installed it. Has anybody thought about how to make that more available? Some companies are starting to generate their own data to sell it, but it's totally unaffordable for smaller companies to be able to innovate with it. And the underlying question being that data was gathered from you, these companies have it, the right to share. Some companies are sharing it for research purposes, but not for commercial purposes. So we'd just like to competition. Does anybody?
Sure. And I want to ask you to identify yourself, where you're from.
I'm from Niko Van Wyk.
Okay, fantastic. The question was around data sharing and innovation on top of that data. I think Cyril could jump in to answer some of that too, but Raegan?
Yeah, I think that's there's a lot to unpack there, because it's hard to imagine what the solutions would be. It's true that if you're a startup or a small company that wants to innovate, you really, in most cases, need access to a lot of data. So these big companies that have a lot of data have therefore a lot of access to innovation. So that's the trend that we're seeing that is, I think, really problematic. But trying to address that, I think, will require some thinking, because I mean the easy answer could be that, and I've heard some startups talk about this, they can ask big companies like Amazon or Google if they can outsource some of their data analysis, but then that kind of further could entrench their their power. So I think it's really difficult to think about, what can actually be done. So I think there's a lot of room for innovation, basically. One of the things that Mozilla has been working on, given the fact that voice, for instance, is actually it's the same thing, not just data, but our voices are, in a lot of silos, like Siri, etc. We have launched an open source sort of project called, what is it called? It's not called text-to-speech. I can't remember the name right now. But anyway, we're asking people to donate their voice into a large open source data set. So anyone can have access to this kind of innovation to develop tools that require voice analysis, because at the moment there's only about 5 companies that really have that access to innovation. So I think there's kind of some projects and ideas that can be done. Obviously that's not enough, but in terms of figuring out how these different companies can share their data while still protecting the privacy of users, of course, complying with security and whatnot, and not, entrenching dominant players. I think that will be really tricky, but it's an interesting area to look into.
Cyril?
Thanks. I think it's true that there's this whole debate about whether there is enough data sharing going on and whether there is enough data for whoever needs data, whether it's small startups or innovators. But again, it's difficult to make broad statements about, for example, there's not enough data which is available. I think it depends on the types of data, it depends on the sources of data, depends on the purposes that you want to use the data for. And depending on all that, there might be data sources. You might be able to collect it yourself. You might be able to buy another company that has it. You might be able to buy the data, as a data set. So it's really difficult to make broad statements, one way or the other. But at the same time, I see this whole data sharing religion in Brussels and in policy-making circles, and I think there's a lot to say in favor of that data sharing religion. I think generally sharing is good, but not always. So we should have a bit of a balanced point of view. You also need to have enough investment incentives for the people who do create data, and you can't just ask them to share their data. You can't expropriate data from whoever has data. And so there should be this balancing between, the static gains from, sharing data and the more dynamic considerations about, do you have enough investment incentives for creating data. Another point that I want to say is that there's a difference between private data and public sector data, and public sector data really should be widely shared, and that's why in the EU, as you know, we have this Public Sector Information Directive, which is now under review, and there's a very strong case to say that public sector data, which was actually funded by taxpayers like us, that should go back to taxpayers. That should go back to whoever wants to use those public sector data for whatever purpose they want.
Thank you, sir. I think we have time for one more question. I think I saw. Actually, ask both. We can maybe address them both. So if they're quick, you go first, ask the question, and you can ask your question, and then we can answer both, and that'll be the end. Please.
It seems to me that the basic, going back a step, for many companies, the main question is, can I just start my big data business on top of my different data that I collect from my customers, which is like a very simple thing. It's not the big Facebook thing, smash Facebook or whatever. It's just, can I apply these tools on my data that I have, which are all collected for different purposes. So the question is, the purpose binding principle, is that do we address this essence of purpose binding in data protection in terms of big data? Do we have the tools to address that?
And I think it's a question about purpose limitation, and I know that Ralf would be able to say something about that. Let's get the other question. And
yeah, just on the question of data sharing and the test we have in competition law to do that, which were developed before, in fact, the importance of data and so on. Do you think there is a need to adaptation or not? And also on the German Facebook case, I would like to hear Cyril or Nico, because this is an interesting combination of competition law and data protection. Do you think it's the way forward, or do you think it's a very dangerous combination that the German practice?
Cyril, Nico, do you want to answer the last question quickly? Then I'll go to Ralf, I think, for the previous question, which I do think came back to purpose limitation in the context of big data, which is a little more squarely in the GDPR space.
Comments, please include
also the Payment Service Directive 2 implementation.
Ralph, you heard it. All right.
And then please competition and price.
Nico?
I can do EPSD too. And I actually don't like to answer your question. I like to answer the previous question. We are so much into we should share data that we totally forget that often when we talk about our data, it's not our data. We have a two-sided transaction system. So if my bank data include data about the persons with whom I do financial transactions, then I think they should know that I'm giving away their information when I share my data. If you subscribe to WhatsApp, you should ask the people who are in your telephone list whether they agree that their data has now suddenly become part of this. And to go back to where the GDPR is totally weak when it's about purpose limitation, I had a very interesting talk with someone who said, a bakery shop should sell bread and not data. And it's an unfair business practice of a bakery shop to get into data collectioning. That's a different business. So there should be a separation between selling me bread and the data that are necessary to sell me a bread, and all the other stuff where they think can make money off. That's a different thing. That's where I would say the GDPR is too weak. I would go beyond saying purpose limitation is enough in this case. No, this should be a forbidden business practice. Just to give you an example of how you can be much more practical with maybe using other regulatory instruments than just sticking to the GDPR.
Okay, since we started with the purpose limitation question, Ralf?
Sorry.
Of course, the GDPR is too weak. If you look at the Albrecht draft report, it could have been much stronger, but it's a political compromise, of course. And especially in the further processing in Article 6, this came from the Council, and we had to kind of enter into a compromise there. On what Niels asked, the purpose limitation in the context of big data, I touched on that earlier in my introductory statements. We have this privileged further processing for scientific and historical research purposes, statistical purposes, and archiving in the historical archiving in the public interest. So there you can, data that you have collected for other purposes, you can further process it for big data analytics, analysis, for example, statistics.
Which doesn't apply for companies usually. So those purposes don't apply for a business that tries to get more value out of it.
No, it could. The companies could do that as well. Even by saying research, we clarify in one of the recitals that this could also mean applied research, so to speak, product development and so on. It's pretty broad. But then we have the important clarification I referred to earlier, that if you do this kind of statistical analysis with the data you have, you can only use it to generate aggregate information and not individual profiles again. If you want to reapply it to the individuals, you need a separate legal basis for that, like consent or whatever.
Okay, thank you. Do you want to address the question here?
There's a question from Alexandre. So I think the question was about, do we have the right legal test under Article 102, so the legal rule about abuse of dominance? Do we have the right legal test for, when we require a dominant firm to share its data, right? And on that point, I would just, I think, very modestly refer to the case law. I mean, I'm not in a position to argue that the case law is wrong or whether that we should change it. I think we will discuss that with my colleagues, if and when the day comes. But I think one point of uncertainty that strikes me is that case law, which is originally about pharmaceutical data or interoperability data in the Microsoft case, or about TV programs in the McGill case. That case law says that there's a higher test, so there's a more burdensome test to meet for the competition authority when you talk about IP, when the asset to be shared is IP. There's a higher test to meet because there the competition authority has to show not only that the lack of sharing is an abuse, but also that abuse prevents the emergence of a new product. That condition only applies when the asset is IP. And then logically, the next question is, when you have a case about potential data sharing, is data IP? And I'm not sure that data is IP. Maybe it is, or maybe it isn't. And I'm not sure whether, what is the state of a public debate about whether data is IP. I don't think there is an EU law definition of IP. I mean, there's an EU law definition of, databases and copyright and patents and trademarks and everything. But at least one of the threshold issues to discuss there would be, is data IP? Because then the test becomes more burdensome.
The Commission wanted to issue a paper policy about the ownership of business data. Will they address this topic there?
That'll be for the next panel. Because I do think I can hear the stampede towards lunch, and I wanted to give Rachel a chance to close the panel.
Thank you very much, Jeremy. I think from the level of debate that's been happening around the room and with the panel, it's obviously been extremely stimulating today, and I know that you've got a lot more questions, and hopefully you'll be able to maybe discuss if anybody's able to stay for lunch with some of our panel members. I think it's been really insightful to have such different viewpoints, to take these issues and look at them from different perspectives. I think we got possibly some commonality out of it. I think we recognize that we do have tools. We need to be thinking about how we best use them and perhaps refine the way in which we use the enforcement tools we have, as well as looking at changing them, which we recognize takes time and may not always be the most efficient way of doing it. I think we've had some very interesting pictures painted for us, what with pregnant data and, Megan's walls, which are being, like Joshua, being possibly broken down by new and innovative ways of small c competition. We look at privacy as a tool within the marketplace. And Cyril's very interesting overview about some of the issues that the competition policy regulators are having to consider when looking at having to use the tools that they have in their own toolbox. So I would like to take this opportunity to thank all of you for coming and for taking such an active role in today's debate. I would like to thank our panelists, who I think have been excellent, very, very interesting and wonderful. And I'd like to thank Jeremy very much for his wonderful moderation, his stimulating questions, and for keeping us on track. Thank you very much.